Actually, the evidence suggests that only a minority of offenders are ever caught or convicted, that those who are convicted are not actually the most risky group of offenders, and the desistance is actually the norm in this offenders group. The predatory, the determined, the repeat offenders, such was the case in Zainab's murder, or unfortunately most recently, I'm pretty sure is the case in Marwa's murder as well. They are in minority. And we actually also tend to forget or ignore that the child sexual abuse takes place within the family unit very often, the context of the greatest risk to children. So in order to further extend this theme, I will now invite Ms. Valerie Khan to take lead. After Valerie, it will be Ms. Robin Maher, who will talk about the American context, and then myself and Dr. Bordon will speak about the multidisciplinary management of sexual offenders in the United States. So over to you, Valerie.
Hi, so hello everybody. So the reason why I have the privilege and the honor to have been invited by Dr. Khuram to be part of this panel is because I represent an organization, a Pakistani one, called the Group Development Pakistan, and we are basically focusing on child protection, child justice, and child participation. So when we say child protection, it means that we focus on countering child marriage, child labor, internal trafficking. We focus on promoting safe learning, and we try to stop child sexual abuse. That's really one of our priorities. We also believe that in order to address those child protection issues mentioned just now, that are basically intersecting with each other, we also need to focus on child justice. And what we mean by that is that we need to focus on avoiding child secondary victimization for children in conflict or in contact with the law at pre-trial, trial, or post-trial stage. And then we also think that if we want to find solution to child abuse, violence against children, and improve child justice, we need to take children's views into consideration while we are developing our actions. Next. The way we work is basically articulated at, I would say, a tripartite level, structural, institutional, and sociocultural level. We ensure that we work according to evidence, according to data, and preferably a scientific data. We focus on capacity building, on awareness, and monitoring, evaluation, accountability, and learning. The way we work is always, again, based on evidence. It's also youth-led because we believe in children and youth as a catalyst and change makers. We are inclusive and creative. We focus also on positive communication, and that's what we hear. We're not here to attack, to blame. We're here to share ideas and discuss and propose to you alternative solutions that, as practitioners, we've been able to identify as potential solutions, and solutions that basically serve the best interest of the child and the general interest of the society. This is very important to remember. And this is the reason why they are aligned with human rights standards, basically, and child safeguarding standards. Next. Next. So, Dr. Khuram has mentioned the various cases of child sexual abuse that have been increasingly reported in Pakistan. What we need to remember and keep in mind when we discuss the solutions to child sexual abuse is that it's not a new phenomenon. So, you know, when we say we have lost our values, we have lost this or that, we need to remember that child sexual abuse is actually an old endemic phenomenon that does not spare Pakistan, but it exists across the board despite culture, religion, or cultural boundaries. We also must remember that sometimes it is ingrained into harmful cultural practices. In the context of Pakistan, we can give the example of batshabazi or early and forced marriage. It is fueled by social economic inequalities, gender discriminatory structures, distorted religious interpretation, defective rule of law, absence of adequate support structures and mechanisms, especially child protection mechanism, social taboos, and also dearth of data and a lack of knowledge. We also must remember that even if we are able to propose a solution that has shown interesting positive results, it does not mean that we have a magic wand, you know, and that everything will just be fixed in a few minutes and in a few seconds. We need to be brave enough to acknowledge what we do not know and that we still need to further research before coming up with solutions that may actually have very negative effects if we are not prudent. And then in the current context, we must also remember that this child sexual abuse has been exacerbated by disasters and displacements and lately by the COVID-19 pandemic. Next. If we look at data, you have an example, but overall, what is important to say is that boys are not spared from child sexual abuse. That basically, it's usually the majority of abusers are basically members close to your family, and also that there is an increase of 14% compared to previous years as per Sahel data. So that means that the rule of silence is increasingly being broken. And then when you look at, I would say, devices such as a new evolution, such as the surge of the internet, this also stands for an additional risk that children have to face in terms of sexual violence. Next. And so because we have this increased, you know, reporting of cases, of course, we have an increased public outrage, anger, and a real demand for strong punishment, such as public hanging, death penalty, and chemical castration. And while we understand the anger, while we have been ourselves as child practitioners experiencing that anger, that frustration, that, you know, that it's sometimes beyond words when you face those cases and when you are trying to protect those children, we are also aware of the fact that when it comes to child protection, we have a sacred duty to put our emotions aside and remain within the ambit of reason. Because if we don't, at the end of the day, the one who's going to pay the cost of our lack of professionalism is going to be the child. And that it is unacceptable and we can't afford it. Next. So what we're here to explain is, you know, what is the problem with the solutions that have been proposed so far and the general public, not only in Pakistan, I would say in many other countries, when they propose violence as a response to violence. So first of all, it's that death penalty or public hanging does not deter child sexual abuse. You've had example in Pakistan, you know, several rapists have been executed. Again, as I told you, the latest data from Sahel shows that there has been an increase of 14%. So by killing people, you don't stop child sexual abuse. More worryingly also, it contributes to the rule of silence, and it does not decrease child sexual abuse, but it certainly decreases the case being reported. And that is problematic because it means that because most of the abusers are within the close circle of the children, and because then the risk of the perpetrator to be awarded death penalty, family members will rather say, you know, we can't afford having that kind of punishment awarded to the perpetrator. So if that case is not reported, it means that that child will never access justice, and that child will never be given a chance to heal and to overcome the trauma. And we do not want that. Further, in case of kidnapping, for example, and we know that this is a problem in the context of Pakistan as well, as in other countries, you actually are increasing the risk of the child to be killed in terms of after being kidnapped, so that the child cannot become a risk, you know, a liability. And when you look at also our anthropological framework, which is very much tribal, the fact of ensuring that there is death penalty being awarded to the perpetrator may also trigger a further intergenerational cycle of violence and trauma, where the different parties are actually going to create what we call the dushman between each other. And this is something that we do not want to happen. Now, another problem, which is more of a legal one, is that as far as public hanging is concerned, it's basically against the Constitution of Pakistan. It violates Article 14 of the Constitution. The Supreme Court and the Sharia Court have been very clear about it. So basically, introducing public hanging is legally not possible. So we need to remember that. We also need to remember that, so the percentage has slightly be updated. It's not 85% anymore, but 73%. Of the death penalty, awarded death penalty, are basically overturned by the Supreme Court, because we know that our forensic investigation is defective. We know that there is a defective policing system, and so, you know, awarding death penalty needs to be done without the shadow of the doubt, and too often we have too many doubts. So we know we cannot, we even have cases where the Supreme Court realized that the accused had been actually was innocent and the person already had been executed. So these are mistakes that we can simply cannot afford, and until and unless our system is fixed, there is no way we can envisage to have such punishment. And then secondly, the most worrying part is that, fair enough, you focus on the punishment, we want to focus on punishment, but until and unless we do not focus on the root causes of that phenomenon, next, we will not be able to stop child sexual abuse. Next slide. So what do we mean when we say addressing the root causes? Well, we basically need to address structural barriers, and that is something that the Pakistani government has actually been working for you know, at least 15 years. It's not like, you know, Pakistan has been witnessing that and has done nothing about it, not at all. So you have had a lot of legislation that has been focusing on improving child protection and trying to improving its alignment with international child safeguarding standards. But we still need to work on transforming the curriculum to promote peace and gender equality, to focus on a child-sensitive environment, to address the gender parity gap, to raise awareness and establish what you call coordinated multi-stakeholders child protection mechanism, and also you know, work on the fact that the public narrative, which is currently prevailing, works on teaching boys consent, and you know, on something which is not only toxic masculinity, but rather gender equality, and where boys are equipped to interact sanely with girls, for example, or that adults are equipped to interact appropriately with children, and making sure that children's voice is heard. So all those elements are basically very important and demand policy and legal reform. Next. At an institutional level, we definitely need to increase women's representation in politics, police, in the judiciary, in the legal and medical professions. We know, and we've seen, research has been done, that whenever women are more present, the agenda, the reform agenda, is actually being increased to address those issues. Additionally, we need to build the capacity of actors of justice and caregivers to identify the sign of child sexual abuse, to be able to respond to disclosure, to develop, to manage the case better, to conduct relevant, again, forensic investigation, prosecution, deal with the trial in a child and gender sensitive manner. And then we also need to reform our prisons. So again, there is an entire criminal justice reform agenda in Pakistan, as well as a reform police agenda. Child courts and GBV courts are currently being established. There has been a lot of training and it is continuing. So those you know, institutional barriers are in process of being addressed, but we need to do more, and we need to do it in a more coordinated manner. Then lastly, we also need to work on socio-cultural barriers. You know, what is positive parenting? How can you ensure that your child is not being neglected? I mean, despite the socio-economic inequalities, you can be, you know, being living under the poverty line is not a crime, and it doesn't mean that you cannot look after your children. But how can we also establish child protection committees at community level and provide bridges between this community, which is, let's be clear, also not digitalized, not sensitized, not equipped, and the service providers, because especially within the context of COVID-19, it is actually essential that support services are still available and are sustained to, and provided to the most vulnerable despite pandemic. So we need the community bridge to do that. And one of the examples could be establishing a grievance, complaint, and reform mechanism or child protection committee. And then we obviously need to conduct mass awareness campaign and introduce life skill-based education in, you know, our TV program or radio campaigns, and that needs to be sustained and supported by the state. Next. So those are measures that, you know, the NGOs and the child protection practitioners are proposing, and they are very holistic. They include multi-stakeholders coordination. They include and cannot happen without a collaboration between the state institution and the civil society. But there are other measures that are more, how shall I say, technical and scientific, and that are crucial to respond and to contribute to what we call the prevention dimension, because child sexual abuse, it's always better to firstly avoid that the child will face a crime rather than focusing on the response. So yes, you need a response to child sexual abuse, but what we certainly need to focus upon more than anything is how in the first place to avoid any child to experience that form of violence. And that's what our next speakers are going to talk about. Thank you.
Thank you. Thank you very much, Valerie. Before we move on to the next section by Ms. Robin Maher about the American context, Ali, can I check if there are any raised hands, any comments, any questions of what we have been talking about?
I cannot see any raised hands. If anyone has a question, they can actually write it in the chat box, and anyone can see it, and the panelists can also respond to the questions.
Okay. So can I give 5-10 seconds to the participants if anybody wants to say anything before we move on to the next section? And I am going to stop sharing the slides from my side, Ali, and I think Robin then will start sharing from her computer. Robin, over to you, Robin.
Sharing my screen. Do you see my screen?
No, not yet.
Dr. Khuram, are you able to share from your side?
Okay. Let me know when to move forward with your slides, Robin.
I will do that. Thank you. Thank you, sir. And good morning to all of you from the United States. I'm so pleased to join you and to be one of the speakers this morning, and to join my friends, Dr. Khuram Khan, Dr. Natalie Bordon, and Valerie Khan. I want to be clear that I've been asked to briefly describe the response of the United States to this very serious problem of child sexual abuse. But I'm going to do so in a very narrow context. This is the criminal response. This is the response of the Justice Department to child sexual abuse. And I want to make clear that this is a very narrow response and not the kind of response that Valerie Kahn just described. We really need a holistic response from many stakeholders. This is only the response of the criminal justice system. Next slide, please. So you heard Valerie talk a little bit about the option of castration. And in the United States, a few United States have permitted chemical or surgical castration as a response to child sexual abuse. Please continue, Dr. Khan. Some states require castration, others permit it as a condition for early release or in exchange for a lesser prison sentence. Continue. And it should be noted that many critics of this approach note that it does not prevent recidivism unless it is only for a specific kind of mental disorder, and I know that Dr. Bordon and Dr. Khan will speak about that shortly, and that this approach is only successful when it is coupled with other kinds of psychotherapy. Next slide, please. The United States also uses what we call indefinite detention for violent sexual offenders. Several of the United States and the federal government provide for indefinite detention of offenders who are determined to be sexually violent. So these are individuals who are held beyond the completion of their prison sentence for their specific crime. And all of the 50 United States require individuals who are convicted of certain sexual crimes, not all of them, but certain of them, to register their name, their address, and other personal details. And this registry is available to the public. And in addition to that fact, many state laws forbid registered sexual offenders from living close to schools, to daycare centers, and other places where children are present. So these are some of the responses that the criminal justice system uses to respond to child sexual abuse. But I want to talk now specifically about whether the death penalty is an option for child rapists. And obviously, as Dr. Khan has said, or Valerie Kahn has said, this is a problem that it transcends all borders. We see the problem of child sexual abuse and rape in many, many countries, if not all of them. But in the United States, we looked carefully at the question of whether the death penalty is an appropriate response. And to begin with, the death penalty is used very rarely here in the United States. There are only a certain number of crimes that can result in the death penalty, and those include an intentional murder with special features and an intentional murder of a certain victim. For example, when the victim is a police officer. And in addition to that, it is not just the crime, but it is the individual who must be evaluated and selected to receive the death penalty. So no matter how terrible the crime, no matter how horrible the crime, it must be about the human being that is punished. So there is an evaluation of that individual and all of his or her life experiences before they decide who is really deserving of the death penalty. And we look at things such as mental disorders. We look to see if a severe mental illness or a mental disorder is the reason for the behavior. And we evaluate that that would be true. If that is true, then that person is not as culpable as someone who does not have a mental disorder. And for those same reasons, we've evaluated and decided that juveniles and peoples with intellectual disability are not eligible for the death penalty. Next slide, please. So we in the United States Supreme Court, which is our highest court and gives us all of our deciding decisions about use of the death penalty, has held that the death penalty should be only for the most serious of crimes and only for those most deserving of execution. And here's what the court has said. The death penalty must be limited to those offenders who commit a very narrow category of serious crimes and whose extreme culpability makes them the most deserving of execution. So at this point, you might ask, what does this have to do with child sexual abuse or child rape? And I get to that in the very next slide. In the evaluation of our Supreme Court, it is murder only that deserves a death penalty. That while child rape and rapes of all kinds are terrible, they are not the same as murder. And for that reason, the court has made clear that only murder should result in a death penalty. Please continue, Dr. Khan. Here are some of the other quotes from the Supreme Court, which I'll let you read for yourself. All of which to say that they believe that child sexual abuse or child rape alone should not result in the death penalty. So while this has been true, next slide please, the Supreme Court did specifically ask the question in a recent case in 2008, can the rape of a child be punished by death? And here the court did a very robust evaluation of all the reasons that the death penalty should be considered for the rape of a child and all the reasons it should not be. In this circumstance, this individual was charged with the rape of his 8-year-old daughter. And in the state of Louisiana, the jury convicted him and sentenced him for a death. This was a specific law that authorized the death penalty for the rape of a child under the age of 12. And the Supreme Court, again, after this very robust evaluation and consideration of all of the input by child experts such as Valerie Khan and others who work on sexual abuse of children, determined that justice was not better served by terminating the life of the perpetrator, that it was better to confine him and preserve the possibility that he and the system would find ways to allow him to understand the enormity of his offense. There were also specific reasons which echo much of what we just heard Valerie Khan talk about in terms of the reasons that the death penalty is not a good answer. First of all, the court notes that when the death penalty is an option, it forces a moral choice on the child who is not of a mature age to make that choice. So because so many of our children are raped by relatives, the child must make a choice to seek and participate and cooperate with seeking the death of a relative, which is very harmful for a small child. It also means that the child and her family may be more likely to shield the offender from discovery, not wanting that person to be killed. And finally, as Valerie said a moment ago, punishing a child rape by death may remove a strong incentive for the rapist not to kill the victim. And put another way, it means that there may be a reason for child rapists to kill the child and eliminate the only witness that could seek their death. So for all of these reasons, the court found that not only is it not the right answer, but it is not going to help deter future rape or protect the very children that we are seeking to protect with these measures. United States seeks other reasons, seeks other options to punish child rapists and also to deter and protect children from future rapists.
Thank you, Robin. I think that's the end of your section.
Yes.
So if I could take a pause here, Ali साहब, और अगर लोगों के कोई सवालात हैं या किसी ने हाथ अपना उठाया है या कोई कमेंट करना चाहे तो please.
Yeah, there's actually one question from Advocate Sabah Inam, and she's actually asking what is intellectual disability from Ms. Robin Maher.
Yes, thank you, and an excellent question. Intellectual disability is the term that most of our mental health experts now use for mental retardation. you may know the term as mental retardation. This is a brain injury that is present since birth. It is different from mental illness and mental disorders, which Dr. Bordon and Dr. Khan will soon speak about.
Thank you for answering
Okay.
the question.
Thank you. Ali, are the slides okay? Are they visible? The one
Yes,
I just...
absolutely, they are visible.
Excellent. Well, thank you. So I am going to quickly touch upon the definitions of sexual disorders as well as sexual abuse, child sexual abuse, from a medical point of view and from the legal point of view. I'm pleased to see that Mr. Wajahat is here with us today as well, and he very kindly provided the legal definition of child sexual abuse as is noted in the Pakistan Penal Code, section 377A, and this is how it reads. It says, whoever employs, uses, forces, persuades, induces, entices, or coerces any person to engage in or assist any other person to engage in fondling, stroking, caressing, exhibitionism, voyeurism, or any obscene or sexually explicit conduct or simulation of such conduct, either independently or in conjunction with other acts, with or without consent, where age of person is less than 18 years, is said to commit the offense of sexual abuse. Pakistan Penal Code section 377B talks about the punishment for child sexual offenders, and this is how it reads. Whoever commits the offense of sexual abuse shall be punished with imprisonment of either description for a term which shall not be less than 14 years and may extend up to 20 years, and with fine which shall not be less than 1 million rupees. Now, on the left, you see the ICD-10, which is the International Classification of Diseases. So in it, there is a section in the psychiatric part of this classification under section F65, and that is about the disorder of sexual preferences, which there are numerous. It starts with fetishism, which is about interest in non-living objects for sexual arousal or sexual gratification. Fetishistic transvestism, so the wearing of clothes of the opposite sex to obtain sexual gratification. The exhibitionism, so that is about the exposing of genitalia to strangers, usually the opposite sex, in public places without closer contact. And usually this is followed up by the masturbation by the offender. Then voyeurism, so that is about a tendency to look at people engaging in sexual or intimate behaviors, such as undressing, for example. It leads to masturbation. Pedophilia, so that is about the sexual preference for children, usually prepubertal or early pubertal age. Sadomasochism, that is the sexual activity involving bondage or the infliction of pain or humiliation for sexual gratification. In this activity, the recipient is called masochism and the provider's activity is called sadism. Now, the multiple disorders of sexual preference. So in one person, at times, there are multiple disorders present simultaneously. The most common combination is of fetishism, So that is the interest in non-living objects, transvestism, the wearing of clothes of the opposite sex, and sadomasochism. Other disorders of sexual preferences, such as making obscene phone calls, rubbing against people for sexual stimulation in crowded places, sexual activity with animals, use of anoxia or strangulation for intensifying the sexual excitement or pleasure, or presence for a partner with preference for a partner with an anatomical abnormality, such as an amputated leg. Other extreme examples are swelling of urine or smearing of feces, or piercing the foreskin or the nipples, or inserting objects into the back passage. And finally, the necrophilia. So that is the preference for having sexual activity with dead bodies. Now, all of these issues only become a disorder if a certain criteria is met. Now, what is the certain criteria? That is also described in the International Classification of Diseases, and there are three. So number one is about anybody who is having any of these urges. That must be recurrent, intense sexual urge and fantasy involving unusual objects or activity. So it has to be recurrent, it has to be intense about whatever thoughts or urges they're having. So that is criteria number one. Secondly, it's not just that they're having thoughts and urges, they should also act on it, or at least markedly distressed by having these thoughts or urges. So that is criteria number two. And the criteria number three is that this preference for any of these issues, the preference should be present for at least 6 months. So this is the diagnostic criteria, which has to apply to any of these disorders in order for them to become a disorder. So, okay, somebody has circled it. I will take a pause here and see if I could get the question, if there is a question about it.
There are actually two questions in the chat box. One from Saqib Siddiqui: is pedophilia ever used as a psychiatric defense? And another question from respected Mr. Akhtar Bambu, is also the judge at the child court in Lahore.
So the first question was, is pedophilia ever used as psychiatric defense?
Yes.
And what is the second question?
The second question is, crime is considered against a state in jurisprudence, but what if a criminal of heinous crime go with lesser punishment? Will it ever serve purpose of justice, especially of juvenile justice? It may be producing adverse results. It may give encouragement. Comments, please, are requested. This psychological response from society upon lesser or disappropriate punishments.
Okay. Robin, can I take the second question first? The issue by the respected judge, which he has raised about the level of punishment and its proportionality with the magnitude of the crime. Do you want to comment from the legal perspective on it? Any
Sure.
comment from
yes.
you? Yeah, please, yeah.
Yes, thank you. And it is a good question. And I don't think any of us are arguing that child sexual abuse or child rape is not serious. It is certainly a very serious crime. And the question is, will it serve the purpose of justice, specifically of juvenile justice, if the death penalty is not allocated? But I think it does. I mean, by reserving the death penalty for crimes such as murder, specifically very serious crimes of murder with special features, we in the United States have made a decision that we are going to call murder the kind of crime for the kind of individual that deserves that specific punishment. We don't think it will give encouragement. All of the data, all of the statistics, all of the research from child experts suggests that the death penalty does not deter. And by not giving the death penalty, it's not going to encourage people not to abuse children. And I think Valerie may have other things to say about this. But the purpose of a criminal justice system is to make these kinds of determinations, to decide that the mental capacity, the mental disorders, the intellectual capacity of individuals to make decisions about how they will conform their behavior to the expectations of the justice system. We have to make decisions like this all the time. And giving everyone the most severe punishment is certainly not the answer. And because we also understand that a more holistic approach, like the one that Valerie Kahn described, is going to give us the best results in terms of reducing recidivism, deterring behavior, and protecting children, we think that is the better approach to take. And maybe Valerie has some words to add to that.
Valerie, please.
Well, I think we also forget something. We have positive examples in Pakistan of crimes that we have managed to reduce, or a criminal phenomenon that we have managed to influence positively without resorting to death penalty. And I always keep on referring to that example. Pakistan has achieved a world record in terms of eradicating violence against women and girls by managing to reduce acid violence by 85% since 2015. This has been done without using the death penalty at all. And why? Precisely because in collaboration with all state institutions, there has been a holistic process. It took time. The real momentum started in 2007, and I'm giving you statistics that date back to 2015. But what we are also saying, for example, is that in case of sexual harassment, there is an increasing number of convictions and women accessing justice since the Anti-Sexual Harassment Act has been enacted, and since there has been all this campaigning for enforcement. Now, it's not perfect. We still have work to do, but I think we need to be, as I mentioned earlier, very much mindful of what the statistics and the sciences are telling us to decide what works and what doesn't work. And the statistics tell us death penalty is not what is working. Holistic approach and reformative justice leads to reduced relapse and sometimes significant decrease in the crime rate.
Thank you. Thank you, Valerie and Robin, for the response. If I could take the other question now, and in the end, I have left a section for discussion, and if still to be said more about this point, we shall touch upon it at that stage. The other question by Mr. Saqib, I think, was, is pedophilia used as a defense, as a legal defense? I think what is meant here. So we will discuss a case later on, and that hopefully will clarify some of these issues further. But can I just say something very quickly, that pedophilia in itself cannot be used as a defense in the court of law. Having said that, there are contributing factors at times which make someone to commit this heinous crime. Sometimes there are mental disorders, comorbid mental disorders present, such as psychosis. Sometimes there are personality deficits present, such as an impulse disorder. And sometimes there are issues, psychological issues in the upbringing of the perpetrators. All of these are dissected by professionals such as me or professionals such as my colleague, Dr. Natalie Bordon. And at times, those are used by our legal colleagues as mitigating factors. So can I just stop here? And I'm prepared to come back to this point at the discussion stage once we have heard about the case of Mr. H, which my colleague Dr. Bordon will talk about. So if I could move on to the next slide, pedophilia itself. So the diagnostic criteria is, which I've just described for any sexual disorder. If you see on the left side of this slide, those three conditions has to be present. So any disorder, including pedophilia, should be recurrent, intense urges and thoughts and fantasies involving unusual objects or activities, that the person should act or at least distressed by those thoughts or fantasies, and that the preference has been present for at least 6 months. So A, the diagnostic criteria A, is that general criteria which I've just described in the previous slide. Point number B, a persistent or a predominant preference for sexual activity with a prepubescent child or children. So that is criteria number 2, which has to be present. And the criteria number 3, or C, the person is at least 16 years old and at least 5 years older than the child or children in B. So this is the diagnostic criteria as has been described in the International Classification of Diseases. Now, some observations I wanted to share with you on this slide, that pedophiles attracted to females usually prefer 8 to 10 years old, whereas those attracted to males usually prefer slightly older children. Some are not attracted to children, whereas others are attracted to adults. The disorder usually begins in adolescence, and that the recidivism or reoffending rates for pedophiles attracted to boys is twice that for those attracted to girls. So this is some of the observations that the professionals have documented in the literature. Now, there are some variants of pedophiles, and we'll touch briefly on the role of the mental illness in this slide. So pederasty is the anal intercourse by an adult with boys. This is a criminal offense and regarded as an assault. Children cannot consent. Therefore, even if no physical resistance is displayed, this is still a sexual violence. The harmful sexual behaviors can occur in young people as part of sexual experimentation. So, you know, the children in secondary schools sometimes engage in such activities. This does not mean, though, that the young person is consistently deviant or psychiatrically unwell. However, this behavior is still wrong and requires to be addressed. And I suppose that just labors the point what Valerie Khan was talking about earlier, the education, the awareness, the engagement of various community stakeholders in order to improve the understanding and insight into the nature of the sexual problems. Finally, the consideration must be given to disinhibiting or mediating factors which may be contributing or driving factor into sexual offending against a child. So psychiatric illnesses such as schizophrenia, which is for our non-medical psychiatric colleague, which is an illness where people lose touch with reality, develop all sorts of odd ideas. Mania, the disorder of moods, where at times you feel high in your moods. The alcoholism, the dementia, which is a disorder of memory. Mental handicap, the intellectual disabilities, can impact cognitive distortion. So cognitive distortions, my colleague, Dr. Bordon, will be able to explain it much better than me, but this is about unhelpful thoughts and thoughts which help the person to justify a wrong act. and develop all sorts of reasons for their wrong acts. So cognitive distortions disinhibit behaviors and detach the individual from reality. So I thought that before I give way to Dr. Bordon and we start discussing the case of Mr. H, I think we'll quickly touch on a model of sexual offending developed in 1984 by Finkeler. It talks about the 4 preconditions which have to be met for the sexual deviant act against a child to occur. So think about Mr. Hashim, which we were talking about at the beginning of today's presentation. So, you know, Mr. Hashim was having these thoughts of having sex with young children. Then in order for, from this point to the point of committing the act itself, there are certain conditions which should be met. So Mr. Hashim should then be motivated enough or find enough motivation to actually sexually abuse, develop that strong urge, the wanting to sexually abuse the child. Then Mr. Hashim should also be able to overcome the inbuilt, the inherent internal inhibitors such as conscience. Mr. Hashim then should be able to overcome the external inhibitors so as to create the opportunity to commit the act with the child. And finally, Mr. Hashim should be able to overcome the victim's resistance, the child's resistance by physically or psychologically or emotionally. So doing it and getting away with it. So let's just talk one by one in a little bit more detail about all these 4 preconditions. So the first one, the motivation to sexually abuse. Now it consists of, as you can see there, it consists of 3 components that explains the motivational drive behind the sexual offending. So the emotional congruence. So that is that the important emotional needs are met through relating sexually to the child. I mean, think about a lonely father who does not have a good relationship with his wife, and then he developed that interest into his daughter, which is very common and unfortunately is not spoken about the familial sexual abuse or highlighted the way it should be. Remember, it is the great risk, the context of child sexual abuse is the intrafamilial circumstances. So emotional congruence. Then the sexual arousal. The child becomes a potential source of sexual gratification for them. The blockage where sexual gratification is not available or is less satisfying through alternative appropriate sources. So that is the condition number 1, which develop this motivation to put the thought of having sex with a child into action. The second precondition, which is the overcoming of internal inhibitors. So this basically explains why the motivation is then put into action, otherwise known as disinhibition. So one has to be sufficiently disinhibited to put the motivation into action. At times, that disinhibition is achieved through the use of alcohol or drugs, or if somebody is having psychotic disorder. So an example of that would be that, you know, hearing the voice from some angel asking that person to have sexual activity with the child because it is going to benefit the child in some shape or form. or an impulse disorder, that the impulse to having sex with the child and an inability to control that impulse. So the personality deficit of some sort. Although these do not fully explain why the abuse occurs, but these two conditions, the one which we have just talked about, these two conditions do account for the behavior of the offender. A man who is both entirely motivated to abuse sexually and also disinhibited may not do so because there are factors outside of his control and determine whether or with whom he should abuse. So there are still two other factors which have to be overcome: the external inhibitors and the overcoming of the victim's resistance. So external inhibitors. And here, I think I just want to come back and keep coming back to this point of what Valerie said, that this awareness, of the parents, of the general public, of the teachers, of the legislators, of the commentators about, and the children themselves about, the cycle of sexual offending and how it occurs and how it can be prevented is so important. So the overcoming of the external inhibitors, it explains the role of external influences in both the child and offender's life. So for example, lack of privacy and the supervision receives from their family, the child, for example, the neighbors, the friends, all contributes towards a restraining influence on the actions of the potential abuser. When I was researching for this presentation, I came across some very helpful short videos on this website by, I think it's a Sahil's website, and I was very impressed with the quality and the message of those videos, and I would recommend if you could browse that as well. Finally, the overcoming of the child resistance is very important in order for the act to finally happen. It is basically about how child themselves determine whether the abuse is likely to occur. So think about Mr. Hashim, the childhood he had described to me, the neglected childhood, the parental discord between his parents, the lack of affection and attention towards him, the neglect and all of that. So a child who is emotionally deprived or lack knowledge about sexual abuse are example which may make a child more vulnerable to sexual abuse. However, abuse may occur regardless of child's behavior because of the use of force or coercion or grooming by the offender. So before I move on to the next slide, where we will talk about the risk assessments, how we go about from the medical point of view and how we liaise with the criminal justice system. Are there any questions or any comments I can take at this point?
There are lots of questions in the chat box. So one question is from Fatima Gill, and she's asking, what is the age requirement of a person to be considered as a child for psychiatric treatment?
Any other question?
Yeah. The next question is from Farah Tofi. What if the person involved had some kind of disorder predominantly throughout their life? Are psychiatric treatments an answer? I would not personally think that we are calling all perpetrators mentally unwell. I understand a holistic response is required. However, if somehow not happy with the point of calling a perpetrator mentally sick and letting them off the hook.
Okay, any other question?
May I suggest, Dr. Khuram, that for Judge Akhtar Bangou, maybe he should speak to clarify his questions, because we're not judges ourselves, so maybe it's not very clear for us. It's more a legal question, so maybe it could be, and maybe Sharafat can help answer, or Robin.
Yes, I mean, that's a good point, Valerie, and if Fatma is prepared to talk That's fine. I think the Fatma's two questions we have just taken. One is from Fatma, which is, I think she is talking about the age limit for a child to receive psychiatric treatment. I'm presuming she's thinking about uh, the child psychiatric services and the age limit. In the United Kingdom, it's up until the age of 18 years where the child psychiatric services are involved. Is that right, Dr. Bordon? Natalie?
Yes, it is. In Britain, we would view, we've got specialist child mental health services, and they would take children and young adolescents up to the age of 18. And at that point, there would be a transition into adult services.
Thank you. And the next question was about not, well, it was a long question, but what I have understood it, the punchline is that not all perpetrators are mentally unwell. Exclamation mark. What should we do about it? Is that right? Who has raised that question?
Farah Tawfiq.
Yes, would Farah like to speak?
Hi, sorry to
Hello, Farah.
ask such a long one.
It's all right.
But I didn't really mean to boggle anyone. It's just that, I mean, I was just going over the criteria that you were, you know, when I was the one who actually circled it, the 6-month-long
I see.
recurring thoughts that a person must have to
I see.
come to be a certain, you know, in the category of a disorder.
Yes.
So then that just makes me think that what if somebody's, you know, been a certain way their entire life, and has not really acted upon a certain point, but then, I mean, are we trying to really just classify that perpetrators have this disorder which can be treated, and then they can go get off the hook that easily for doing heinous crimes? Or are we just looking at it as a possibility? I know that this is just a hypothetical situation that came in my mind, that a lot of the psychiatric aspects of this do give a buffer to the perpetrators. So I mean, I just would like to know your thoughts and the panel's thoughts about it. Thank you.
Okay. Natalie.
Yes, I was going to say,
I could see that your thinking process, so I'll let you go first.
No, I think it's a very good question, and actually it's something that I agree with, and I think as we move on to the next part of the presentation, hopefully it'll start to cover and make sense of the points that you're making, that we don't think that all perpetrators who abuse children have a mental disorder per se. What we have to do is understand those that do, those that there are treatments available, and that different types of treatments are going to be helpful for different types of offenders. But there are a cohort of perpetrators who do require risk management, and do, perhaps we'll come on to it later in our slides in terms of Scottish law, who do receive indefinite life sentences because they're deemed so risky that they can't actually be returned to the community. But at the heart of all that, there has to be a good, robust psychological risk assessment to fully understand the factors, so that we're not just treating everyone who commits crimes against children in a sexual manner in the same way. We have to understand the motivating factors, internal, external, as we've seen in the model that Dr. Khan's explained. We have to understand that, and we have to understand the individual's, perpetrator's ability to want to change, to be able to change, and the criminal justice ability to manage them before we would actually look at what kind of sentencing options, how risky they are, etc. So I don't want people thinking that we are saying that everyone is mentally disordered as such, but there are people, there are still treatments that we can do for some people, regardless if they have a mental disorder or not. Hopefully that answers your question. If not, I'll go through my slides and if it might make it a bit clearer, but I can always come back to it.
Thank you, Natalie. And also, I think the point is that it's the bespoke response to a particular case on by case basis, not kind of fit for all, mantra we're talking about here. And it's not about defeating the course of justice. Is it actually? It's about facilitating it, isn't it? In order for the courts to understand better why the crime has occurred. Not only that, but how can it be prevented in the future? The very important issue of recidivism. Any thoughts on that, Natalie, before I perhaps quickly invite Robin and Valerie to say something about it?
I would just echo what you've said, Dr. Khan, that it's about bespoke treatments, understanding individuals' risk and understanding their own motivating factors and matching that up with the punishment effectively. Thank
you. Natalie, Robin, would you have any comments at this point, or you want to leave them till the end?
Yeah, I'll say one thing very quickly. For hundreds of years, our only response to crime was to punish, and to punish severely. And we have evolved as a society, I think, in a much more sophisticated way now. And we also have the contributions of science and medicine, of the work of many professionals to help guide us when we think about what our justice system should look like and what our rule of law should look like, the response of our system to incidents of crime. And so when we're not talking about letting people off, I mean, I hear that a lot in the United States. Well, if they don't get the death penalty, then we're really letting them off. No, we're picking a more appropriate punishment for that crime, for that individual. Understanding all of the motivations, all of the life experiences, all of the reasons that crime was committed. And this is a much more sophisticated and appropriate response of a criminal justice system than simply punishing harshly with, as you said, a one-size-fits-all. So I just want to mention that when we say no death penalty or no severe harsh sentence, we're not saying no response at all. And we're not saying no punishment at all. We're just saying that punishment should be tailored appropriately for that individual, understanding everything we know about the motivations, the background, and the reasons that punishment should be given to that particular individual.
Thank you.
Can we request Mr. Akhtar Bangu to unmute his mic and ask his question?
I think they're having some problems, Ali Sahab. So
can we move for the next question? The next question is actually from a psychologist, Andali Fayal, and the question is for you, Dr. Khuram. If any person is not able to control his urges, then this thing classify that person, understand mental illness. How can we punish that person who is not psychologically well and who cannot understand what the person has committed?
Yes, well, the question is from a psychologist, and we are quite fortunate today to have a psychologist with us. So, Natalie.
I guess trying not to go into too much psychology jargon to answer the question. I think, yes, there are people who don't have a mental illness, a diagnosable mental illness, but do have issues with impulse control. Within the world of psychology, we would look at what we call underlying needs. So we would look at what's actually driving that lack of impulse control. What is it about that person that makes them act out in certain ways? What disinhibits them, that they can't actually control their impulses? And we would offer psychological therapy for that, regardless of having a diagnostic label. we would still see that as something that we could try and target. I'm not saying it works all the time, but it is something that we do work with. I do work with on a daily basis, and we can actually make progress in terms of people being able to manage their impulses on a much better level, or at least being aware of things that are going to disinhibit and aggravate those impulse control.
Yes, and just to add one quick point to what Dr. Bordon has just said. So the work which Dr. Bordon does in terms of, you know, dissecting this issue, the pathology, let's say, which is impulsivity here, for example, that help us to then think about the legal culpability, the legal responsibility. So there are only three outcomes really. One is that despite of person's impulse disorder, impulse deficit, the reasoning, the judgment was not distorted that much where it would then absolve that person from the wrongful conduct they have done. So that is one outcome, and they should be punished for it. Secondly is that the pathology was such that it had affected the judgment of that person, the reason of that person to an extent. And here we then offer advice to the courts, to the legal professionals, and how that can be used as mitigating factors to perhaps lessen the punishment. And the third is that the deficit was of such magnitude that it completely obliterated or just totally affected the reasoning and the judgment of that person, and hence, you know, they were then classed as insane at the time of the offense. So there are these three possibilities, but in order for us to reach to one of these, it's a laborious process. And this is exactly what Dr. Bordon is going to start talking about from the next slide. I think this is the right time to transition to the next slide, Dr. Bordon. Are you ready?
Please do.
All right, there you go.
Thank you, Dr. Khan. So I guess what my part in this presentation is to try and give you a brief overview of the very long and complex process of psychological risk assessment that we would be doing for all of our offenders and our patients. I guess just giving you an overview of risk assessment, there's lots of different what we call tools. So these are accredited risk assessment tools that have looked at what factors are actually linked to various types of offending and guide us towards thinking about how these factors relate to that individual, and that helps us form an assessment of risk. As I've mentioned a few risk assessment tools there. There are three main types of risk assessment methods. Unstructured clinical judgment, which is effectively a professional who has some, if any, experience having an overview of a case and just making a judgment of risk based on their experience, which obviously there's lots of different pitfalls to that. We then have something called actuarial risk assessment, which is effectively like number crunching risk assessment. So they look at static factors such as age of the first sexually violent incident, the age of the offender, the age of the victim, and basically they put them into grids and they give you an assessment of risk, but it doesn't take account of any of the individual factors. We then have moved towards what we call structured professional judgment, which basically attempts to minimise the limitations of the unstructured clinical judgment while taking the benefits of the research and the actuarial risk assessments that have actually been shown what factors link to different types of offending. So there's a bit of flexibility in that highly professional clinicians can use these risk assessments, they can use their own judgment, but within the bounds of the research within the evidence base. Next slide. So I guess in terms of answering the questions earlier, it's crucial to identify the risks posed by offenders that each of them have within themselves, and this is how we then would tailor further risk management and interventions. In terms of how we define sexual violence, very similar to what Dr. Canna spoke about before, it's actual attempted or threatened sexual contact with another person that's non-consensual. So this includes rape, communications of a sexual nature, so non-contact offences, and also violating property rights for sexual purposes, so theft of objects of other people to be used in that fetish manner. Next slide. So in terms of risk assessment, it's the process of gathering information, and we use this information to make decisions. The best risk assessments will take account of all the information that we can gather on the individual. So that would include interviews with the perpetrator, if there's any previous psychological or medical testing available, review of their case notes, contact with people that know them well. We would take all that information and add that into the risk assessment. And then the main decision is what measures we should be putting in place to minimise the risk posed by the offender. That's what we want the risk assessment to do. Our job as the assessor is to try and understand how and why people choose to commit sexual violence and the factors involved in it. So is that due to sexual deviation? Is it antisocial attitudes, irrational beliefs? We want to understand the individual factors for the perpetrator, and this allows us to then form a treatment and risk management plan, which will hopefully minimise future offending. Next slide. So the main tool that we use in Scotland is the Risk of Sexual Violence Protocol. It's used for men aged over 18, although it can be used for older adolescent males, for 16, 17 and women, but there's a degree of caution there. It's not as accredited for these populations, but it's the best that we've got, and we wouldn't be using it for children aged 15 and younger. There's 22 individual risk factors within 5 domains that we would look at. What our aim is to do is to look and see if these factors are present within the individual, and then look at the relevance of these factors to that individual's risk of offending. The good thing about this tool is that idiosyncratic factors can be added. So if there's something that the assessor feels is crucial to this individual's risk of offending, we can add that in to the tool as well. Next slide. So this is a bit of an overview. These are the 22. This slide and the next slide are the 22 factors within the 5 domains. So within the first domain, we've got sexual violence history. We're looking at what has the individual actually done, not just what have they been charged with, but what offending is taking place or inappropriate behaviour is taking place. What are the coercion measures that they used to gain access to their victims? We then look at the offender's own psychological adjustment. So what are their own attitudes? Do they have attitudes that support having sex with children? Do they believe children to be sexual beings, sexual knowing? Do they have problems with their own stress and coping? That they can't regulate their own emotions, they can't navigate through adult relationships, and this is the outcome of it. So we'd want to be looking at that. And obviously within the point number 10, we'd also be looking at, has this person been the victim of childhood sexual abuse also? Next slide. We then do look into mental disorder. Within that we have obviously the sexual deviance, which Dr. Khan has covered. We look at major mental illness, but we also look at personality disorder as well. We look at disinhibiting factors, for example, problems with substance use. And then we've got a category on social adjustment. So is that person a sort of well-rounded individual who's participating well in society, or are there problems with that which leads them to offending? Do they have stable relationships? Do they have stable employment that may be protective factors, or actually are they using their employment as a means of gaining access to the victim? The last part that we would look at would be their manageability, in terms of, has this person ever been under any kind of treatment or supervision before? What was the response to that? Where they did they abide by all the kind of rules or the legislation that was put upon them, any restrictions that were put upon them, or is this the first time that they've came to treatment, and what's their view of treatment and being supervised going forward? Next slide. So as you can see, this is an overview of what we would call the 6-step process of risk assessment. So it's all these factors come in this order, and each of them feed into the next part, which at the bottom, the summary of risk judgment and case prioritisation. That's where we would be determining how risky this person is. Are they a high risk of reoffending? And what services should we be putting in place to manage that risk? Next slide. So in terms of psychology, and to my psychologist colleagues out there, risk formulation is what we have our expertise in. We're effectively trying to draw on previous psychological theories that are well established, and then pull in the individual's problems, thinking about their life experiences and what might be keeping these problems live, what might be keeping them in place at the current time. So I guess what we're trying to do is have a bit of a narrative of that person's experiences and how they've got to where they are today, and how that relates to their offending as well. In terms of a sexual violence risk formulation, we are wanting to make sense of the risk posed by the individual, and then look at the interaction and role of the relevant risk factors, early warning signs, and factors which explain their pattern of violence. Next slide. Once we start to understand a bit about the offender, why they've offended at that time with that victim group, we then would do something called scenario planning. And this is it's not a prediction about what will happen, but it's thinking about what risk could they pose going forward if no risk management was put in place. So we're starting to think about the nature, the type of sexual violence that they may go on to commit if no, as I say, if no risk management, no supervision requirements are put in place. We think about the victims, the context, the level of harm that they may cause, and within that we start to think about signs that may indicate to us as professionals that the individual's risk is increasing. So early warning signs, for example, are they increasing their use of alcohol to disinhibit them? Are they, when they get into conflict with other significant relationships, does that make it more likely that they're going to go and reoffend? We need to be aware of these warning signs so that we can intervene to stop further offending taking place. And this is central to the development of risk management strategies. Next slide. So the aim of risk management is to prevent harm to others, a good lives model within the offender, only restrict and compel where necessary, and as professionals have defensible decision makings, not defensive decision makings. So the good lives model is a well-known model that we use quite frequently in the treatment of sex offenders and in fact violent offenders as well, that we're all striving for the same goals in life. We want relationships, we want employment, we want a good life. However, some people can't meet those needs in a pro-social way and may go about it in anti-social ways to try and meet the same goals that we're all aiming for. So it's our job as the psychologists, as the therapists, to try and help them to understand this and look at other ways they can meet these needs in a more pro-social way. Next slide. Within risk management strategies, there's lots of things that we would be considering to ensure that risk is contained and minimised. So we would be looking at monitoring the individual, so that can be general contact with their doctors, with their clinical team. It can be police putting surveillance on people that they think are risky. We also have supervision, which is more restrictive, so that would be placing restrictions such as where people could live, who they could have contact with on them, that to try and minimise reoffending. The big one there as well is what treatment should we be looking at? And as I say, our risk assessment process should have identified what areas people have deficits in, and that should be the areas that we're targeting. There's also a thought about considering victim safety planning, so minimising harm to potential future victims by increasing the victims' skills. So for example, if we have people who, it may be ex-partners or people known to them, giving them a plan of what to do should this person get in contact with them, whether that be personal alarms direct to police stations or personal safety training as well. It's very, very important in terms of risk management that we have open and timely communication between lots of agencies, and we'll come on to it in a later slide, but within Scotland this is what we call MAPA, multi-agency public protection arrangements, that all agencies are working together to communicate. We also have to look at contingency planning. So as I mentioned earlier, if we're starting to see these early warning signs, we know that this could be increasing the individual's risk. We have to have a plan pre-thought out in place what we do should that risk be increasing, so that we can intervene before something happens. And most importantly, we have to ensure all these factors are constantly under review to ensure that they're relevant to the individual at that time. Next slide. So in terms of psychological treatment, as we've kind of alluded to earlier, treatment's most likely to be effective when it's tailored to the risk, needs and offence of the actual individual offenders, rather than a blanket approach. The treatment should be based on the offender's underlying needs as identified in the risk assessment and formulation. So within that, we may have things like cognitive distortions, dysfunctional beliefs, dysfunctional beliefs that may encourage someone internally to offend against children. It may be that they have a lack of ability to form relationships with age-appropriate peers and therefore gravitate towards children. Programs, cognitive behavioural therapy based programs actually show the best and most significant effects in reducing reoffending. As you can see there's been various studies that find that CBT does make an impact, a significant impact to the chance of someone reoffending in a sexual manner. And these better outcomes are achieved when the treatment itself is delivered by highly specialist therapists and the treatment programs are more individualised. There are various programs out there that are more manualised, and they don't have as good an effect as a program which is actually delivered by someone with specialist training who can adapt it to the individual. Next slide. So within this, we have two approaches. I guess Dr. Khan and myself coming from the psychological and psychiatric side. Within the cognitive behavioural approach, we want to build what we call a relapse prevention plan. We want to allow the offender, if they can, to understand their warning signs, their high risk situations, and start taking some responsibility for their behaviours. We want to develop that good life plan with them, which is built on their strengths, their protective factors, and hopefully that helps them gain insight into their behaviours. Part of it all is getting to develop victim empathy. As I said previously, mentioning cognitive distortions, a lot of people will think that actually they're doing no harm, but it's our job to make them realise that that is harmful to the child and that they have to have empathy towards their victims. It might also be if people have been abused themselves, linking, as Dr. Khan mentioned in the case earlier, linking their own childhood trauma to their reoffending. And then Dr. Khan will explain some of the organic treatments.
Yes, so basically the underlying goal of the organic or medicinal treatments is to suppress the sexual urges by, and I'm afraid there's quite a lot of jargon there, so inhibiting gonadotropic pituitary function by medroxyprogesterone acetate, by blocking the androgenic function, the surgical castration, which is very, very common. I think, if I'm not mistaken, in all of the Europe, the chemical castration, I think only happens in Poland. as per my own research. And I think out of the Europe, it's in Malaysia, I think, where it is practiced. And then the damaging the brain areas, which thought to influence sexual behavior, but the neurosurgery is no longer used in the United Kingdom.
So I guess just thinking about what Dr. Khan said in terms of the chemical castration, there's obviously lots of different methods. There is some evidence that it can reduce reoffending. However, in terms of interpreting the results, we have to be very cautious. In the cases where it's used and been a bit more successful, the offenders themselves have volunteered to take this medication to reduce some of their sexual urges. So it could be seen that actually these people are more motivated to try and undergo treatment to deter them from sexually reoffending. Additionally, I think it was mentioned earlier that in terms of chemical castration, the best results are when it's combined with psychological therapy, that the two work hand in hand together. I guess as a psychologist in the place where the hospital that we work, we have used chemical castration for some offenders who have been willing to take the medication, and that their offence profile is very much that they were becoming sexually aroused for a high volume of the day, which was actually causing lots of distress. So within that context, it was successful in addition to the psychological therapy for understanding that. However, for others, and having that blanket approach of enforcing people to take these tablets or procedures to chemically castrate them, it may actually increase their riskiness in terms of sexual reoffending, as it may increase their risk of sexual frustration. So we have to be very cautious about when these treatments are used, how they're used, and as I say, without repeating myself too much, but coming back to the individual and understanding their risk before we use this blanket approach. Okay, so just to kind of tie up, I guess we'd spoke about a case of Mr. H, who's a patient that both myself and Dr. Khan worked with in the State Hospital in Scotland, who was actually admitted to the hospital due to his offence of attempted murder. However, once we started to go back and do a thorough assessment, he had a long history of sexual offending against others. This is a kind of brief overview of his charges. So his first documented sexual offence was aged 10 against his 5-year-old niece. We have a charge called lewd and libidinous behaviour in Scotland, which is sexually inappropriate, whether that be exposure or touching. And he was charged with this age 13 against 2 boys. He then faced a rape charge against a 15-year-old female at 15, and at 18 he was charged with exposing himself to a group of teenagers. He continued to display inappropriate sexual behaviours on the ward towards fellow patients when he was first admitted as well. Next slide. So in terms of looking at his list of charges, you would think that's someone who's a well-documented pattern of sexual offending, and that you can actually see the increase in the escalation of the significance of the offending and the harm to the victims. What we then did is we conducted that risk assessment process and started to think about that individual and their formulation and their underlying factors for offending. What it actually showed was that this person grew up in a house where inappropriate and incestuous sexual relationships were conducted between several family members over several generations. So at a young age, Mr. H himself was the victim of sexual abuse perpetrated by his brother. And when he disclosed this abuse to his mother actually told him that this was normal behaviour between siblings. So he therefore grew up thinking that this is normal behaviour to be sexually inappropriate with other members of your household. The household itself, there was also significant physical abuse. and he was unable to learn how to behave appropriately in both intimate and non-intimate relationships. He had no sense of boundaries, socially or intimately with others. He had a long history of alcohol and drug use, which also acted as the disinhibitor to his sexual offending. Initially, treatment focused on improving his social skills, establishing those boundaries, and addressing his substance misuse as well. He then completed a bespoke sex offending treatment programme, which looked at the specific factors associated with his sexual offending. Through this treatment, he gained significant insight into his previous negative behaviours. He learned a great deal about appropriate boundaries and actually was able to alter his skills to show that he could behave in a more appropriate way with his peers, with other people on the ward. And he gained the skills to address his needs, his own underlying needs, without using sexual violence. This patient then actually was able to be discharged from a high secure hospital to a lower level of security, because he was able to modify his behaviour and understand the triggers for his potential future offending and put skills in place to try and manage that. Next slide. So as we mentioned earlier, risk management strategies in Scotland, one of the main things we've got is the multi-agency public protection arrangement, which is actual legislation that aims to protect the public by requiring police, NHS, health services, prison service and local authorities to work together to assess and manage the risk of each individual managed under these conditions. Within the MAPA, we look at registered sex offenders, mentally disordered restricted patients, or any other individual that's been deemed a risk of serious harm to others. Within the legislation, agencies can use a range of safeguarding measures such as surveillance, electronic tagging, curfew, sexual prevention orders, which are orders that are used. The person doesn't have to have been convicted of a sexual offence, but they're deemed at risk of committing one, so we can actually put restrictions on their movements and who they have contact with prior to that to try and reduce the risk of sexual harm. Next slide. So we obviously have a sex offenders register, and I think Dr. Khan's going to talk about that.
Sorry. So people convicted of an offense of a sexual nature are subject to basically notification requirement, which here in the United Kingdom is called sex offenders register. So anyone who is convicted of an offense of a sexual nature is then required to give the details to the police, and that is then held in a register and then shared with the agencies in the future, that information if required. The information is kept by the police. The nature of the information is the passport number, something which we have here, which is the national insurance number. An equivalent of that in Pakistan would be the national identity card number. The bank account details, the DNA profile, the fingerprints, and the photographs. Can I just take this slide, Dr. Bordon? Is that all right?
Yes.
Yes. So in the United Kingdom, the violent and the sex offender is a database of records of those required to register with the police under the Sexual Offence Act here in Scotland 2003, those who are jailed for more than 12 months for violent offences, and unconvicted people thought to be at risk of offending. It just, I mean, from the Pakistani context, you would have heard the motorway incident where this woman was unfortunately sexually assaulted in front of her children. And I think the main perpetrator is still at large. This perpetrator had a previous offending history, but there was no mechanism in place to use that information to mitigate and reduce the risk of recidivism, which is unfortunately very common in this offenders group. The register can be accessed by the police, National Probation Service, the prison, Her Majesty's Prison Service in the United Kingdom. It is managed by the National Policing Improvement. Sorry, there was a disturbance. Policing Improvement Agency of the Home Office. We have, I think, if I'm not mistaken, we have a psychiatrist today here with us, Dr. Briju Prasad, and he's from India. Dr. Prasad, are you there? Do you want to comment on from the Indian perspective? Yeah.
Yeah, no, thank you, Dr. Khan. First of all, I should say it's very interesting discussions today, and I did comment on the group chat about this, particularly around the topic of sex offenders register, and I feel there are so many parallels between what's happening in India and Pakistan around the issue of child sexual offences and sexual offences against adults as well. Actually, so I think the aftermath of the 2012 horrific rape incident in Delhi, actually, there was a huge discussion about this, actually, and amongst a lot of other things, one of the things that came out was the sex offenders register. And I don't know the exact name that they call in India, but it was very similar to that, which records information about the patient's fingerprints, photographs, DNAs, and their identity card details and all that stuff. Of course, there are lots of privacy issues here, actually, and sex offender register in itself is not set in as a legal basis in India, but it came through an executive order. So it's interesting how this can evolve into societies, and also it can be used effectively to help manage sexual offenders and help them to rehabilitate. So I see this as another tool, really, to help in this whole process.
Thank you, Dr. Prasad. I found this information that India began its sex offender registry, and this is administered by the National Crime Records Bureau. Since its inception, it is reported to have over 450,000 people to begin with. It can be accessed only by law enforcement agencies and has names, addresses, photographs, fingerprints, DNA samples, and something which is, you would know better about it than me, Dr. Prasad, the Aadhaar numbers. I don't know what they are. I'm presuming they are this national identity number of some sort.
Yes, yeah, you're right.
Yes. So I think there is a call in Pakistan as well to replicate this system as one way of managing the risk. So the forensic issues, I mean, Robin has talked about the indeterminate sentences, and but Dr. Bordon, the order of lifelong restrictions, do you want to take this slide and just...
So I guess one of the sentencing options that we have in Scotland is something called an order of lifelong restriction. Effectively, that is an indeterminate life sentence. In Scotland, life sentences are used for murder. However, you can have an order of lifelong restriction without actually having committed the offence of murder if you're deemed that your risk is so high of reoffending. They're used for both violent and sexually violent offenders. Prior to an offender receiving this sentence, the judge would actually request a risk assessment be done by a highly specialist psychologist or psychiatrist to actually determine what are the risks that this person pose and how high are they, and can they be managed within the framework of our current kind of criminal justice system and community settings. If the person is deemed such a high risk, they will receive an order of lifelong restriction, which means that they can be kept in prison or detained in a hospital until such time that the professionals involved in their care feel that their risk has reduced enough to allow them to be managed within the community.
Okay. Well, thank you very much, Dr. Bordon. Ali, how much time is left
We
this
actually
session.
have 5 more minutes, I guess. So Mr. Wajahat had raised his hand. So can we actually take a question from him?
I will take.
Ali, if I may, right before Mr. Wajahat, George Bangu, I think his sound system is back. If we can try, and then Wajahat can be next, because I think he has to go.
Mr. Akhtar
Could
Bangu is the first one to go.
Sorry, can I just interject if you don't mind, Valerie? So we have Mr. Wajahat, Mr. What's the name of the gentleman?
Akhtar Bangu.
Mr. Akhtar Bangu, and I think we also have Professor Iqbal Afridi, the president of the Pakistan Psychiatric Society, here with us. Is he still there, Ali?
Yes, I am here.
He's there. So I think we'll try to accommodate the three gentlemen in the next 5 minutes. It's the task for you, Ali. Go ahead.
So can we start with Mr. Akhtar Bangu?
Please. I think there's something wrong with his mic.
Hello.
Okay. Yeah, could Professor Afridi go first?
Bismillah. First of all, I'm very thankful to all of you, especially the organizers, and I can see the very dynamic people who are very experienced person, and I'm especially thankful to Dr. Khuram, who always try to spread the knowledge of forensic and other issues related to the other developing countries like Pakistan, where these services are yet to be developed. And today's topic is very interesting and is very sensitive to be talked in our country, and we need a lot of work to do and to save these innocent people, and also the legislation component is important, and also the implementation and the prevention aspect is very good. While I was looking at the slide that the registration process, I was thinking on that our youngsters are very capable to utilize digital system. So why not the registry should be digitally monitored, and so that they can easily register themselves from home rather than going to the various places like our police stations are not very friendly. So therefore, and they are not capable to deal such sufferers. So, and the second thing, in Pakistan, we are really having a lot of shortage of the forensic psychiatrists. Is absolutely not there, but the child psychiatrists are also less in number. Only few are there. We at Pakistan, or at the platform of College of Physician and Surgeon, are starting second fellowship, and hopefully this year we will start this second fellowship. So therefore, their assessment is very important. So at the initial stage, a lot of evidence are lost. And the second thing, that there are psychosocial issues. People don't want to talk about things, especially the people want to hide that they don't want to be defamed, and especially those who are the female sufferer. Once I know there was a case, and the mother was reluctant to tell what happened to her child to the husband, and although he was a lawyer, and I just requested that please give me the detail where this person was so that I can write them, but they were reluctant. They shifted from Pakistan to America just for these things. So therefore, a lot of repercussion, enormous impact on the family, and the sufferers are there. So therefore, we have to prevent. And nowadays, the media is also telling, and this responsive reporting is also lacking in our countries. So in a developing country like Pakistan, India, Bangladesh, we should develop some strategies to help each other and eradicate this menace of child sexual abuse. Thank you very much.
Thank you very much, Hafeez Saab. I will find out and share the details of the electronic way of running of this sexual registry in the United Kingdom. Thank you. Akhtar Saab.
Hello.
I think he still has problem with his mic. Can we
Okay,
go with Wajahat?
Wajad Saab, please. Baat
Okay,
kijiye.
thank you, Dr. Khuram. First of all, I appreciate all the panelists. They presented very well. The discussion was very informative. You explained about pedophilia. That was very informative. And Robin explained about the United States laws about child sexual abuse. That was also very much interesting. And Valerie about criminal justice system in cases of child sexual abuse. That was also very interesting. I have a question as well as a comment. First, the question is with Robin, that what is the conviction rate in child sexual abuse offenses in the United States, as well as if any lawyer from England, what is the conviction rate in child sexual abuse offenses in UK? And my comment is on Valerie's presentation. Valerie talked about public hanging and chemical castration for child sexual abuse perpetrators. Nowadays, there is a debate going on that public hanging must be done for the child sexual abuse offenders. Actually, I want to clarify here that there is already punishment available of death sentence for sexual abuse offenses. Whoever commit the sexual abuse, whoever commit the rape of any person under the 16 years of the age, the punishment is life imprisonment or death sentence. So the punishment is already available. If someone commits the rape of any child, there is a punishment of death sentence. But the problem is that sexual abuse is defined in 3 different ways. The punishments of sexual abuse in Pakistan Penal Code, they are present in 3 different sections, in the form of sexual abuse, in the form of sodomy, and in the form of rape. But the definition of rape, that is not present in the Pakistan Penal Code. So how the court will clarify that what kind of sexual abuse has been committed? So instead of focusing on the public hanging and chemical castration, we need to focus on the unique one standard definition of the sexual abuse and what kind of punishment should be awarded to the offender accordingly. And the other thing is that the conviction rate is very low in Pakistan, so we need to focus on the forensic investigation methods to investigate sexual abuse cases, and the conviction rate must be increased so that deterrence must be created in the society. Thank you very much.
Thank you very much.
Can we take last 2 very brief questions from Ms. Satya and Mr. Sharafat Ali?
Could I, are you able to extend the time by 5 minutes at all?
Absolutely.
Lovely, fantastic, because I don't want to lose this opportunity, and there are some really good discussions happening.
Perfect.
So with that peace of mind, Mr. Sharafat is must, and who's next person you said?
Ms. Satya.
Ms. Satya, but before I let the 2 participants go ahead with their comments, can I ask Robin if she has any comments to the question posed by Mr. Wajahat?
Yes, thank you, and thank you for the question. Unfortunately, there's not a very easy answer to this question because there are so many variables. I'm sorry, I'm hearing an echo. There's so many variables that will affect whether a crime is successfully prosecuted, the age of the child, the willingness of the child to cooperate with the prosecution, the availability of any evidence of the crime. There are so many variables across the board, even the gender of the child. So it's very difficult to answer your question with a specific figure. I can say generally that many crimes are not reported, as you well know, and that it is very difficult to prosecute these crimes successfully because of all of the variables I just mentioned, because these are young children, and also the credibility of young children. They are very suggestible, and so their testimony may be called into a question at times. So for all of these reasons, I would guess that the successful prosecution rate is quite low, lower than we would like it to be. And all of this suggests to me that turning to the criminal justice system for a harsh response is not the answer. Because if we cannot successfully prosecute these crimes and therefore lead to some sort of deterrence effect, the better approach, in my view, is to adopt something by way of what Valerie explained earlier, and that is a more holistic approach, or the approach that Natalie and Dr. Khuram have described, which is a more scientifically based approach based on what we understand will be effective against individuals who seek to abuse children.
Thank you, Robin. Sharafat Saab, please baat kijiye. Assalamu alaikum.
Can we please let Ms. Atiya speak? I think Mr. Sharafat is having issues with his mic.
Okay. Atiya, please go ahead.
Am I with you? I've unmuted. Am I audible?
Yes.
Atiya, please go ahead.
Acha ji. Thank you very much. Now that you have got extended time, I will try to very quickly in shorthand give a few suggestions, because I think that today's discussion has been phenomenal, absolutely, because we are talking about an age cohort, children under 16, they have no voice and they have no vote. And therefore today and yet they have the most horrendous abuse throughout the country and violence. What I would now, we've heard a range of very technicians and practitioners, and now where do we go from here? Do I have your permission to make 3 suggestions? The first was, yes, the first, and I'm addressing this to Dr. Khan and to the group Development Pakistan, because I'm a person who believes that and in Pakistan, we certainly need to do something very realistic and practical now. So the first thing, we talked about law, and we talked about justice, and there we talked about public punishment. We talked about the fact that culpability is only for murder, etc. But we also know that the abused child has a living death. We also know that most of the abuse is within the family itself. So I would strongly recommend that we look at how justice is best served, and we enter into a dialogue, this group, and we can bring more in, and we enter into a dialogue immediately in the present with government, with the Minister of Law and Justice, with his setup. And the presentations which you all have given today are just so excellent, and some of the comments are so excellent that we need to take those forward for informed decision making in terms of policy, laws by the government. The second is that we have heard a lot also about Mr. Hashim, and he's not one person. There are many, many, many other Hashims who are disturbed. They are the perpetrators. I would like to suggest in Pakistan, we have very few psychiatrists, no centers, no dedicated space to look after. We don't have a care center which could be developed into a good practice for looking after disturbed persons. And I would like to suggest here the University of Health Sciences in Punjab. Maybe we could enter into a dialogue with them, and I'm sure that we could move well in that direction. My third comment is what we have heard from everyone, and that is that we need a holistic approach. I would like to add to that not only a holistic approach, but we need a partnership approach. And in that partnership approach, I'm going to suggest the possibility of having a zero abuse project in Pakistan. And I think that this is the need of the time, and we can go forward together. The first step would be that we develop a child protection information gateway, because there are many NGOs, CPOs, and the government itself which is working in this regard. And we could put together a zero abuse project where we would do just focus on two things, because the law and justice, let's deal with the government, let's deal with professionals, with medical technicians in terms of the perpetrators, and care and health care, which is required through a bigger research project with a university or whatever. But here, what I want to suggest is that the NGO sector, the CPO, led by Valerie and her group and Dr. Khan, and we do two things. One is try and make a protective family environment, and the second is a child-friendly social and legal response. And there I will stop. Do you think it is feasible or possible, or something that is way out?
Thank you. Thank you. I've been taking notes, Athiya, what you have been talking about, and some very important and interesting themes have come out. I mean, well, I just wanted to ask you a little, sorry, there's echo. Can you hear me?
Yes, I can.
Yeah.
Yes. Yes, so the child protection gateway concept, which you are talking about.
Yes.
When I was researching for today's presentation, I came across a website here in the United Kingdom, and anybody can Google it. It's called Stop It Now. Now, that website, I saw several sections in it. And this is totally confidential. So if Hashim, Mr. Hashim, rest in peace, he could have then gone onto that website. There's a specific section where you say that you are having sexual problematic thoughts. He would have clicked on that section, all confidential, got all the necessary information, support, including the psychiatric support. Remember, he was struggling with all those of distress. He went into his grave with that distress. So I totally agree with it. I mean, on that website, there are other sections about parents, that what should you do as a parent to keep your children safe. They could click on it, they go in there, there's information available, as well as one-to-one input or group input. And there were other sections as well. You know, so is it something along those lines you're talking about?
Yes, it is precisely along those lines. And I have not had an opportunity to see this great website in UK, yes, which you are talking about. Yes. I also very strongly support, feel the need in Pakistan to develop the sexual abuse registry, and yes, to work with government. But I think, Dr. Khan, what is needed now, that we cannot allow our children to be emasculated this way. Yes. It's too much. And I think that can we put a group together as a spin-off from today's very, very enlightening session. And I'm sure you will find a diverse group of people who would want to come in and work under the leadership of whichever yours and Valerie's, and if we make a consortium and get this together.
Yes, this is precisely what we intend to do from this point onwards, Athiya, which is a collaboration between Valerie and the like-minded people and colleagues from the criminal justice system, as well as the Pakistan Psychiatric Society. The president is here for that reason, because I think he himself was very much interested. And so I will take these themes forward with Professor Afridi in order to mature this further. Sharafat Sahab?
He's there.
Yes, I can hear you.
Yes, Sharafat Sahab, please go ahead.
I briefly, I have to refer first, Honorable Judge Akhtar Bhangu, where he talked that it's a offense against state, the rape is offense against state, and there should not be a minimized or a minimal punishment. It's not about the decrease of the punishment or about increasing of the punishment. It's about the proportionate punishment. And more particularly when you referred that whether it would be juvenile justice, for example, when you give a decreasing or a minimal punishment. Basically, it's about the reformation, and it's about not giving the lesser punishment, but it's more about thinking about the future, that how to reform that perpetrator and how in future that perpetrator would not become another time a perpetrator. I have another comment where I would like to respond to Mr. Wajahat, where he said that there's no definition of rape. I would very humbly disagree, because the section 375 of Pakistan Penal Code is all about, it gives a length of, I would not, since you do not have right now the time to listen, so it's a full page definition of a rape. So there is, I mean, there is a rape, that is a definition of a rape that's explained there. I had a question to you, Dr. Khuram, but since I don't know that you got the time right now or not.
No, please go ahead.
We particular have basically here issue that conviction rate, as Valerie mentioned, it's maybe, to be very honest, we do not have a very scientific study on this, but it's just estimations and general references that we say that it's only 4 to 6% punishment. And since we have been involved with the, judicial process for quite a long, so we hear it from the judges and from the prosecutors that it's very difficult actually to prosecute, because particularly in rape cases, the evidence mostly is on the body of the victim, and the victim is not in early hours, but immediately is able actually to express himself or herself. So generally it's a silence for maybe for many hours, or maybe, for many weeks even sometimes. So due to the lack of evidence, generally there's no conviction. So sometimes it's not actually that the severity of the punishment. Basically, the perpetrator know that there are loopholes within the justice system, so somehow he or she may escape after committing this heinous offense. So the death penalty becomes irrelevant. Either even the perpetrator knows that he may not be able even to get the 10-year or 12 years punishment. So the specific question is about improving the investigation system, more particularly bringing into the modern scientific evidence. How, that you would suggest to our investigation authorities, how we can improve this process, how we can collect a better evidence to prove the offense once it's committed.
Very good question, Sharafat Saab. It is not my area of expertise. I don't know if Waheed Saab is here. He's a criminologist from University of Jamshoro in Hyderabad. I don't know if he's here today because he might be able to help us with this. Yes, please.
Sorry. Hi. In terms of just the forensic area of, in terms of evidence gathering is not my area of expertise, but in terms of actually interviewing children and gathering information from the victims. Within Scotland, we have quite robust ways. They're not entirely perfect, but they have been proven to increase the victim's ability to tell their story. We have specialist teams from the police who join up with social workers to interview children in a way that's not leading, that we acknowledge that children can have difficulty communicating depending on their age and stage, but all this is taken account of so that we can try and gather as much information from the victim in a consistent manner, and that there's no then comeback in terms of when it goes to trial about the victim being led or being suggestible, that we try to get it from the beginning, we try and get it right. And ensure that we are supporting the child to disclose the events. And as I say, that's done jointly with social work and police in a specialist centre that's child friendly to try and make the child as comfortable as possible. Sorry, just that hopefully answers part of the question.
Yes, it's about the specialist training, the specialist interview techniques and skill, how to approach the victim, be an adult or a child. So one way of gathering the evidence. I think what Sharafat Saab was talking about also is that the initial, the trauma of the assault then make the person incapable of giving the necessary information to the police, and hence, this deficit in the investigatory process. So this is one way of going about it, because these specialist people, they are trained to support and facilitate that person to speak and provide the information. Is that right, Dr. Bordon? And who are these people? Are these people kind of police people, especially trained, or somebody else? Can you just?
So it's actually it's joint between, as I say, police officers who obviously have their expertise in the law and the kind of investigative process, and social workers who their main focus is child protection and the needs and interests of the child. So it's actually a joint interview. So you've got these two speciality clinicians actually working together to support the child to tell their story, with their own expertise in mind, in terms of the police coming from what is actually going to be helpful and useful in an investigation of a criminal case, and the social worker maintaining what is actually in the interests of the child at this time. So it's specialist training that these individuals will have to go through after they have obviously qualified in their respective fields, and that's how it's managed.
Yes. Robin, do you have any comment on that question by Sharafat Saab?
No, I think Natalie said it very well. Exactly.
All right. Okay. Excellent. Thank you. All right. So, is there any other comment before we draw it to a close? Okay. Excellent. Well, listen, everybody, thanks for attending the program today. Myself, my colleague, Dr. Bordon, Robin, Maher, Valerie Khan, we'll be happy to receive further comments on questions or other questions and engage with you. I think this is, as how we see it, this is just a start of the dialogue and the thinking and the effort to mature this response, the scientific response towards the child sexual abuse further in Pakistan. So we have plans to do more programs electronically as well as in person as well. We are contemplating and kind of designing a program in Karachi, December this year, but it will all be advertised and communicated. So thank you very much once again, and Assalamu alaikum.
Thank you so very much, everyone, for joining today. I would like to thank all the participants and also the panelists. For retrieving the video, please visit our website, gdpakistan.org. Within 1 hour, the live video of the webinar will be available on our website. I'll repeat, our URL is www.gdpakistan.org. Thank you very much. Please take care.
Thank you.
Thank you.
Thank you.
Thank you.